Apologies for the loss of audio there. In the meantime, the Federal High Court in Abuja has dismissed a defection suit instituted against the 27 members of the Rivers State House of Assembly loyal to the Minister of the Federal Capital Territory, Nyesom Wike. The suit, seeking to replace the 27 lawmakers on account of their alleged defection from the People's Democratic Party to the All Progressives Congress, was on Friday thrown out on various grounds. Among others, Justice Peter Lifu, who delivered the judgment, held that the suit instituted by the Action People's Party was statute-barred, having not been filed within 14 days allowed by law. Justice Lifu said the case was a gross abuse of court processes on the ground that several suits on the alleged defection of the same 27 lawmakers had been adjudicated upon by the Federal High Court. Now, to discuss this, we are joined by a legal practitioner and public affairs analyst, Vincent Ottaokpukpu. Thank you, Mr. Ottaokpukpu, for joining us on the news.
Thank you for having me. Thank you, our wonderful audience.
Now, Justice Peter Lifu held that the suit instituted by the APP was statute-barred, having not been filed within 14 days allowed by law. Now, are these technicalities meant to be valid, technicalities like this, in invalidating genuine cases?
I think the realm of technicalities ought to have been dispensed with in the current judicial system. The Supreme Court, Oputa JSC, and other many justices of the Supreme Court have, stood their ground and said that without law there will be no justice, and without justice, law will be laboring in vain. And justice and law are like great lions tied on the same day. And whichever is stronger, it depends on a judge to decide. Oputa was specific when he said that spirit of justice does not reside in its technicalities. Law is nothing but the handmaid of justice. That flexibility, which almost became a rule of law, often serves to render justice grossly. The most fundamental and essential role of a judge is to dispense justice. From this point, I beg to disagree with the findings of fact of the Justice of the Federal High Court that the action filed by the Action People's Party ought to have been commenced 14 days from the date when the defection of the 27 lawmakers occurred. That was on the 11th day of December 2023, as the case may be. Now, when you look at what does, and also that the matter constitutes a pre-election matter and ought to be filed within 14 days. And having been filed 8 months after the said course of action, it constitutes a statute-barred within the context of the provisions of the Constitution. I beg to disagree, because when you look at what constitutes a pre-election matter within the interpretation of the Constitution and the Electoral Act under Section 84, subsection 14, made it laconically and copiously clear that pre-election matters are matters which occur before the conduct of the main election. Before the conduct of the main election. When you look at Section 84, subsection 14 of the Electoral, it said, an aspirant who feels that the political party has not complied with the Electoral Act guideline or constitution of the party in the process of selection of a candidate at the primary election should approach the High Court or Federal High Court for redress. Now, when you now look at Section 31, subsection of the Electoral Act, which now says on the issue of false information to INEC, when an aspirant has submitted false information to INEC, and a co-aspirant can also approach the Federal High Court or High Court to set aside that nomination and they declare the person has lied on oath in Form CS001, which is now from EC 9. Now, given by this interpretation, when you look at Section 285, which the my lord based in that findings of fact, Section 285, Section 14 define what a pre-election matter is all about. 1A. An action where an aspirant has questioned the nomination process of his political party. 2, where the man has questioned the action of a political party, disqualifying him to participate in the election.
Okay.
2, 3, that is C, when the person has qualified a political party questioned the action or decision of INEC, disqualifying their candidate from participating in the election.
So Vincent, in summation, so because we don't have enough time to deal with this, in summation, it would mean that whatever grounds the justice or the judge rather had placed his verdict on does not really serve as the true interpretation of what the Constitution means. In a nutshell, is that what you mean?
Yeah, yes, that is my subjective opinion that the decision of the court may not be in tandem with the current position of the Supreme Court or what constitutes a pre-election matter, and as the case may be.
Okay, so let's look at another side to it. Let's look at another side to it. How do several suits on the alleged defection of the 27 lawmakers that were adjudicated upon by the Federal High Court amount to gross abuse of court process highlighted by Justice Lifu?
Yeah, the court said that the suit filed by the Action People's Party constitutes a gross violation and abuse of court process because there are multiplicity of other court actions pending in other courts. Now, the court referenced the case filed by suit 681 filed by the Fuller, the then speaker, and other lawmakers at the Federal High Court before Justice I've forgotten that, now promoted to the Court of Appeal.
Okay.
Justice Okolowo promoted to the Court of Appeal. So but the question is this: for you to determine that a suit constitutes abuse of court process, if we have been filed before, you must be able to show that the parties are the same. The plaintiff that came to court is not part of the processes of suit parties that are already existing in the other court, as the case may be.
Okay.
What the man filed today is that INEC should be compelled by the court to conduct fresh or by-election with respect to the 27 seats that have been declared vacant by the Speaker of the House of Assembly in Rivers State, who cleansed office and declared the seat of these defeated members on the 13th of December 2023. That's what the suit of the plaintiff is all about.
But he also said, sorry, Vincent, he also said that, the replacement of the lawmakers had earlier been rejected due to lack of sufficient evidence. So, of course, what other evidence would be sufficient now to ascertain the need to have these people, their defection being ratified?
The defection has been ratified. We must have the strength, because my Lord, in the delivering judgment today, referenced the judgment earlier delivered by my Lord, Honorable Justice Omotosho, on the 22nd of January 2022. Incidentally, I was in court that day when that judgment was pronounced. That judgment borders on the suit was against the National Assembly, restricting them from coming to take over legislative power functions of the State Assembly of Rivers State under Section 11 of the Constitution. That this situation has not arisen to such that the National Assembly is being invited to take over, and other issues. That is what that suit is all about. Then the suit of my Lord Okolowo, which was filed by Fuller and 27 others, is to restrain PDP or INEC or some other persons from declaring their seat vacant until the suit is determined. And I heard there was an expected application to restrain parties from tampering with the rest, and which was made also on notice, as the case may be. Okay. But you know that the High Court of Rivers State had also given a final judgment on the subject matter, wherein that he said that the defection have affirmed the defection of the 27 members and declared their seat vacant, and ordered them not to stop parading themselves as the legitimate elected lawmakers of Rivers State House of Assembly. I know that suit has gone to Court of Appeal, as the case may be. But when you look at the case law, which Supreme Court have done before, in the case of Fedeco versus Uganda, which was held in 1983, based on 1979 Constitution, the court interpreted section 241 section 164 of the 1979 Constitution, which also the Supreme Court repeated in the case of the local case on defection now on Abagunde versus Attorney General, on the Ondo State House of Assembly. And the Supreme Court made it clear that because these people, the state elected members of defected members, claimed that there was a defection, there was a division in PDP, that the secretary of the PDP, national secretary of PDP, there was defection, there was a division, and the national, that kind of thing.
Yes.
But when you look at what the Supreme Court held in Abagunde versus Ondo State Assembly, Supreme Court said because Abagunde was elected by Labour Party, but later defected to ACN.
Okay, Vincent.
Not defect because you cannot use defection at the state level to justify division anticipated at the national level. It can only be division at the national level that can warrant defection. So, give and take, the judgment of today a scam. It has not solved any problem in Rivers State. It has not solved any problem. It has not restored the...
All right, Vincent, let's just let's keep it at that. I understand how far you would be looking at the interpretations of the law and the inconsistencies that we have seen when it comes to delivering judgment. But then we want to say thank you very much, Vincent Ottaokpukpu, for sharing your thoughts with us on the news. Thank you.
Thank you. Thank you.